Good, e good evening, everyone, and a very warm welcome to you for the fifth in our Black Lives Matter series of seminars. Sorry for keeping you waiting for a few minutes, but we were having some technical difficulties, which are being resolved as I speak. So my name is Maya Sikand. I'm a Silk at Downing Street Chambers. I specialize in actions against the police and generally actually holding public authorities to account through private law and public law claims, death and custody inquests and public inquiries. I'm co-comparing this event with my colleague in Chambers, Fiona Murphy. She, as you will know, has extensive experience of representing victims of police crime, including a number of matters where families used inquest conclusions of unlawful killing as a platform to successfully compel homicide prosecutions. She was also instructed by Hickman and Rose on behalf of the family of Dalian Atkinson, about which we will hear further this evening. This really is part two of our tripartite police accountability series. The first one, which a number of you attended, examined the role of the IOPC and whether it was achieving accountability. Today, we turn the spotlight on the Crown Prosecution Service in the context of deaths in police custody. We hope to explode some myths and ask some difficult questions. We have a stellar lineup, and I will introduce our speakers in due course, but first we're going to kick off with an introduction from the man who needs no introduction and who we are proud to have as an associate member of Chambers, the indefatigable campaigner for racial justice, amongst a few other things, Shadow Justice Secretary David Lammy, MP, who has supported more than one constituent who has lost a loved one whilst in custody of the state. I should also say, actually, that we'll be keeping strictly to time so David can go back to parliamentary duties. David, over to you.
Well, thank you very much. And can I just say, I remember one of the first conversations I had with Maya, it's probably almost 20 years ago, as a young MP, with Maya berating me on this issue and how wonderful it is that Maya is now duly the Silk that we all know her to be. And Fiona and I, very sadly, I've had constituents who've needed her support. So this is a subject that has been a theme in our national life, frankly, for most of my life, and is certainly a theme since becoming the Member of Parliament for Tottenham and replacing the great Bernie Grant 21 years ago. We know that a real problem exists, and we know that it's existed for a very long time. The facts, frankly, speak for themselves, and that is that 1,700 people in the UK have died following contact with the police since 1990. Yet the debate in relation to police criminality tends to centre around the issue whether the problem is caused, if you like, by a few bad apples, or whether there is an issue of systemic, if you like, problem that we need to discuss. The critical issue, it seems to me, and the question that we should be asking, is whether the mechanisms for police accountability are sufficiently independent and robust to ensure that no police officer is above the criminal law, nor beyond the reach of misconduct sanction. And absent effective mechanisms to pluck the bad apples out of the barrel, you can understand why there is a perception, and I found this in my review, that the whole barrel is turned bad. And that is definitely the perception amongst Black communities, very sadly. The experience of victims of police criminality informs us that there is systemic failings, and it's failures of those mechanisms, most particularly in relation to the intersection of crime and race, or police crime and race, and of course gender can be an issue that threatens to undermine public confidence in policing itself. The government has accepted that the system is failing as long ago as 2015, The Home Secretary acknowledged when setting up the Angelini review that the system was not fit for purpose, not only preventing deaths in police custody, but also ensuring that families are better supported throughout the process and that lessons are learned and implemented quickly. And I think it's important to keep in mind some of the following cases. Why was the prosecution of PC Monk for the manslaughter of Daley and Atkinson, the first ever prosecution of a police officer for homicide committed on duty in over 30 years? And why did that prosecution take 5 long years? Of course, I recognize that individual cases and individual discussion may be prohibited today, but many of you will keep that in mind. Why has it taken so long? And in those same 30 years, there have been 10 other homicide prosecutions. Why did each and every one of them result in collapse or acquittal? And why, after an inquest determines a person died unlawfully while in police custody, are so few prosecutions brought against the officers found to be responsible? Why does the IOPC often move so slowly, it feels, to investigate cases of police misuse of force? Why does it suggest when 10% of all cases brought to the IOPC take more than 12 months to resolve? And how can it be that the last successful prosecution of a police for the death of a person in custody was in 1986, almost 4 decades ago? So those are the facts. They're facts that resonate in communities like the one that I represent. And there's a sense that the mechanisms aren't working, that we need to be bold enough to say this. Is it a problem with the IOPC being full of ex-policemen? I know that it is better than its predecessor, and indeed better than that predecessor, and indeed, and we discussed this in our last gathering, that it holds up against international comparison, but it is still the sense that the police are investigating the police, and that ricochets into communities. And there are questions, of course, that we keep in mind as a result of Hillsborough too. It would be right here to name check the work of Inquest, whose ongoing casework and monitoring shows that 14% of deaths in police custody or otherwise following contact with the police since 1990 are people from a Black, Asian, or minority ethnic background. I think it's also important, whilst there's a lot of emphasis on those who are Black, to recognise the context for those who are from Gypsy, Roma and traveller backgrounds, who often don't have the advocates and certainly don't quite in Parliament in the same way. It's also important to mention the proportion of those deaths in custody where restraint is a feature, the proportion of deaths in custody where use of force is a feature, and the proportion of deaths in custody where mental health related issues are a feature. And coming to mind for me in terms of restraint, use of force and mental health is the case of Roger Sylvester in my constituency. But we also, of course, have to see this in a wider context as a whole, and particularly when we're talking about the treatment of Black people. We know Black people are far more likely to experience every forceful police tactic there is, particularly handcuffing, with force also used about 5 times more often on those that the police perceive to be Black versus those that police perceive to be white. Black people in England and Wales are also disproportionately more likely to have force used against them by police officers, especially firearms and tasers. Black people experience 12% of use of force incidents in the 2017-18 period, despite accounting for just 3.3% of the overall population. There has been something that has happened, clearly, in the aftermath of the murder of George Floyd. In June, the UN issued a report which analysed racial justice in the aftermath of the murder of George Floyd and called on a number of countries, including the United Kingdom, to end the impunity enjoyed by police officers who violate human rights of Black people. I'm using the UN's language. The report featured 7 examples of deaths involving police, including the case of Kevin Clark, who died after being restrained by officers in London in 2018. The report concluded that the available data painted an alarming picture of system-wide, disproportionate and discriminatory impacts of people of African descent in their encounters with law enforcement and the criminal justice system in some states. As the Angelini review showed as far back as 2017, a view amongst many families of those who died in custody, campaigners and lawyers who do not feel that the IPCC was truly independent of the police or police culture. Furthermore, we know, as I've said, that this does still exist in relation to the IOPC, although there may have been some improvements. There's a broader context, of course, as we meet at this time, and the broader context is the fallout of the killing of Sarah Everard, the murder of Sarah Everard, and of course the current Casey review, and a wider discussion of corruption, frankly, in the police that's dominated the news, independent of race issues. There is a sense, particularly in London, that the Met are under considerable pressure. So that is the context. Just to get to some of the solutions, Inquest has made a powerful case for the creation of a national oversight mechanism to collect, analyse and monitor the implementations of lessons arising out of state-related deaths, too often whether it comes out of inquests or indeed whether it comes out of reviews. The implementation of what should happen isn't properly monitored or enforced. And in my opinion, the need for that mechanism is urgent and must include consideration of why, after an inquest determines a person died unlawfully while in police custody, so few prosecutions brought against the officers are found to be responsible. We must also bear in mind that deaths in police custody are the tip of the iceberg. Failing to prosecute the unlawful and excessive use of force on people ultimately creates a climate of huge distrust. I think that's about it to open up.
David, thank you so much. Our next speaker, we're extremely pleased to have Rosemary Ainsley with us today. I'm hoping she sorted out some of her technical difficulties. Are you there, Rosemary?
Yeah, are you able to hear me on the phone, Leah?
Yes, we can hear you, which is fantastic. So I'm going to go on and introduce you. She's head of the Crown Prosecution Service Special Crime Division, which is a central casework specialist division dealing with a wide range of high-profile, complex and very sensitive cases throughout England and Wales, including cases of police corruption, death in custody, disaster and multi-fatality cases, and all cases of gross negligence manslaughter and corporate manslaughter. She heads a team of 28 lawyers based at London and in York, 8 of whom are senior specialist prosecutors who are ticketed, that is personally approved by the DPP to deal with death in custody cases. Rosemary is going to address some of the challenges and recurring themes in death in custody cases. Rosemary, I'm sure our audience wants to know whether there is an institutional reluctance in the CPS to prosecute police officers. So I'm going to leave you to take the floor. If you're just going to be a voice, that's fine, as long as you can hear and we can hear you.
Yeah. Thank you very much, Leah. I can only apologise for my appalling internet connection tonight, which is why I'm phoning up. So I hope you can all hear me, and please do let me know in the messages or whatever way you can if you can no longer hear me. The screen's frozen for me, so I'll just keep talking until somebody tells me not to. Can you all still hear me?
We could until a second ago.
Yes.
Can you hear me now?
We can.
Yes.
We can. Yes. Yes, we can.
Yes, we're back. But muted. You need to unmute. Ah. Rosemary, can you hear me?
Yes, I can hear you. Can you hear me now? Okay, I do apologize for the connection.
All right, just stay unmuted.
Okay. So I will wait for you to just wave or give me a sign if you. Oh, thank you, everybody. That's great. So just to give a little sort of, I suppose, an introduction of who we are for anybody who's listening who hasn't come across Special Crime Division. So as Maya said, we're a central casework team, and we cover the whole of the country. We're based in York and in London, and we have a team of very highly qualified lawyers. So they're either senior specialist prosecutors or specialist prosecutors, and we deal with, as Maya has said, major disaster cases. So we're dealing with Grenfell, we're dealing with the Hillsborough case, any rail or air disasters, all death in custody cases, police corruption cases, if they're serious police corruption cases. So the case that David's just mentioned of Sarah Everard, that was a case that we dealt with in our division. And all death in custody cases are handled by senior specialist prosecutors who go through a very rigorous process of ticketing by the Director of Public Prosecutions individually. So this was a process that was put in place after the Attorney General's review in 2003. And as part of that review, not only are all decisions in relation to death in custody cases made only by senior specialist prosecutors, they have to be approved by the DPP himself or herself. And in any cases in which it's not clear beyond doubt that it is not a prosecution, then that case goes to senior counsel. So that can be senior Treasury counsel or senior counsel who has experience in death and custody cases. So the process for any decision making is really quite rigorous and quite robust. The type of cases we deal with are many and varied. So we would deal with all death and custody cases. That would include deaths in prisons and then deaths in police custody, all following police contact. So that involves police shootings, police pursuits, deaths following restraint, deaths following detention. That could be in transit, at arrest, in police custody. And we deal with, of course, suicides in police custody as well. So when dealing with police deaths in custody, we would be working with the IOPC. And I think the IOPC and I deal actually with all death and custody cases. And that's a process, I think, which is always undergoing some kind of review and some kind of progression, we hope. So we have a memorandum of understanding with the IOPC in relation to cases referred to us. And that's in the process of quite a rigorous review at the moment. And I'll come on to that a little bit later. But once the case is referred to us by the IOPC, once they've decided there is a criminal element to that case, we will then begin a process of family liaison. So that will take the form of an initial meeting just to explain who we are, what we do. And then at a later stage, it will involve an issues meeting. So that's a meeting which the family can tell us of any particular issues they would like us to address in any review or issues that are concerning them. And then once the decision is made, we will have a meeting that would either be to explain the decision not to prosecute, if that is the case, or it would be a meeting to explain the charges, if there are charges, and how the court process will work, and also to take them through that process and provide them with any assistance that the family may need through what is often quite a traumatic time. So one of the things also I know that would, I think, be very helpful, and I'm sure several of our audience probably represent bereaved families. We're at the moment developing a death in custody booklet designed for families, and we're hoping that might explain the process and something that can be given to them very early on, so that they can understand how the decision-making process works. And hopefully that will provide some extra knowledge and some extra background to what we do. One of the themes that I think that has emerged from family meetings and has emerged indeed from reviews that have been done, including the Angelini review, is the delay in these cases. They do take a much longer time than normal homicide cases. There are many reasons for that. Some of the reasons, of course, are the complexity of the cases. So they're quite different to normal homicide cases. The suspects may be quite clear in these cases, but to assess whether the conduct actually amounts to criminal conduct as opposed to, for example, disciplinary conduct, it can be a very difficult process and involves very legally complex decisions. There's a great importance for expert evidence. Now, that can be in relation to medical evidence, which, for example, in the case that David's mentioned of Daly and Atkinson, that was very complex medical evidence in relation to causation of death. And it's very important that we get that right and that we instruct the right experts and ask the right questions. There's also other evidence that can be required, such as evidence of restraint. So we might need an expert on restraint to explain what is acceptable procedures for restraint and what isn't, and so that they can advise the jury accordingly. We might need driving experts in relation to police driving, the parameters, what their policies are, what their processes are, and in relation to police procedures at police stations, what is the role, what are the regulations, what are the practices that are acceptable for example, custody sergeants. So expert evidence is crucial in prosecuting these cases, and that does build in a significant amount of time. Cases might also come to us after inquest, so these cases may not have come to us originally, but come to us after inquest, in which there has been a finding of unlawful killing or a narrative verdict, which would give us some cause for concern. And also, of course, there's the victim's right to review, which is a case if we decide not to prosecute, there is a victim's right to review, and that will involve a completely fresh review by a lawyer in a different unit. So, for example, if the case was dealt with in London, it would be dealt with completely separately for a victim's right to review by the team in York, by a lawyer in the team in York. But of course, there is a need to improve and to reduce delay where we can. And that is where I think our liaison with the IOPC is so crucial. And that is where I think we need to look at our memorandum of understanding and see where processes can be reviewed. And we're looking at that in quite close detail at the moment. I know it's something we discussed with Helen at an earlier meeting that we had. But what we're looking at is having regular monthly meetings built into that memorandum of understanding, so that we can look at whether a case file deficiencies, we can advise the IOPC at an early stage which experts to instruct and what to ask those experts, and hopefully we can see any case file deficiencies at an early stage and be able to assist the IOPC. I think in relation to themes that we've seen from the cases we have, I would have to say, and I think I may have mentioned this earlier, is that we see a definite theme of mental health concerns. So that could be in relation to, obviously, suicides at police stations, or in the case of alcohol abuse, drug abuse, which can cause quite acute behavioural disorders, could cause episodes which often involve the police engaging in restraint, and restraints, of course, that, as we know, can go horribly wrong and result in death. And there also is, I think, a concern in relation to, I suppose, how mental health episodes are dealt with by the police, and whether they have and whether they are sufficiently trained in dealing with these episodes. So I think there's definitely a theme that we've noticed in that, and of course the case that David has mentioned of PC Monk, which was the Daly and Atkinson unlawful killing. That was a case where there had been a very serious episode, a mental health episode, which had resulted in the police arriving at the scene. And then, of course, as we know, that was a case where what had initially been, I suppose, an attempt by the police to control the situation, which then, of course, very tragically involved such a serious assault to cause the death of Dalian Atkinson. Now, that case wasn't the first case, of course, to be prosecuted in 30 years. When David referred to that, I know that he meant it was the first conviction that had been in some considerable time. There have been a number of prosecutions, and as we know, this was the first conviction. It's very difficult to know exactly what lies behind that and why juries don't convict or haven't convicted in some previous cases. I think in this particular case, and there's also, of course, a limited amount I can say in relation to cases that are live, and this case is, of course, still live because the co-accused will be prosecuted again next year. But I think perhaps the difference in this case is that there was very clear witness evidence of witnesses who had perhaps seen initially an attempt to control the situation by PC Monk, the officer who's been convicted, which then turned into a very, very different scenario and turned into a very serious police assault. And that evidence was quite clear from those witnesses. So I think that was a great assistance in that case. But what lies behind juries and how they see these cases, I think is probably something which would be well worth looking at, but not something I can probably comment on further. So I hope that's been of some assistance with the role that we have and what we do. And I hope you've been able to hear me okay, because it's I know it's not the most ideal way to be talking on the phone.
Well, it was just brilliant to be able to at least have you participate, Rosemary. So, better than nothing. And I'm sorry that that your internet connection has been so difficult. So thank you very much. Our next speaker, our last speaker, is the brilliant Helen Stone, a solicitor specialising in actions against the police and death in custody inquests at Hickman and Rose. She has acted for families in a number of well-known police death cases, including 3 that have resulted in prosecution of police officers: Thomas Orchard, Azelle Rodney, and most recently Atkinson, only that last one being successful as far as prosecutions are concerned. Helen, over to you.
Thank you, Maya. I probably should add, and I'm sure Rosemary would want me to add, that there was a successful prosecution in relation to the Office of the Chief Constable in relation to the death of Thomas Orchard in relation to health and safety offences. So I'm sure Rosemary would want me to flag that, but not in relation to the officers themselves. Yeah, I mean, I have been involved, as Maya said, in a number of different cases, and have had, I think it's fair to say, both positive and negative experiences in relation to the interaction with the CPS in relation to that. Some of that as a result of the IPC's involvement as well, but obviously our focus today is in relation to the CPS, although I think it is very important to note that obviously the CPS can only be as good in their prosecution or potential prosecution in relation to the evidence that they have available to them and gathered by the IAPC, which is why I know Rosemary and I have engaged previously in relation to the importance of the interaction between the CPS and the IAPC and early interaction. So I think it's really welcome to hear that the Memorandum of Understanding between the CPS and IAPC, which was previously agreed in 2016 with then the IPCC, is being reviewed. And certainly, Rosemary, I hope that that really does have some focus on very early engagement from the IAPC with the CPS, albeit that it should be happening now. But I think a number of those who work in this area, we have real concerns about that happening and whether the IAPC are appropriately identifying at a really early stage whether a potential criminal offence has been committed, and therefore seeking the expertise of your team. That is a real concern, and I will reiterate something that I think we've previously spoken about, that training is hugely important for the IOPC in relation to this area, recognising potential criminal offences and the evidence that needs to be gathered in relation to that is just so key. And it's such a concern for the families that we work for when we hear that evidence gathering has not taken place at an early stage and it's possibly lost forever. Sometimes it just cannot be rectified. So I do think, I reiterate that I think that training is really key, and I would encourage the CPS to be engaging with the IOPC in relation to that. And I was really interested in what you were saying about the facts that you think that the witness evidence that was gathered in relation to the Daly and Atkinson case was so crucial. Clearly gathering that evidence, going door to door, finding out whether there is footage from a Ring doorbell, for example, that might be of assistance, that is going to be crucial. Those early hours, we all know, are so important. And ensuring that the IOPC are doing that and the CPS encouraging them to do that, I think is particularly important. You obviously mentioned delay, Rosemary. It's just such an important issue for the families that we work with. It really is one of the biggest concerns, both in relation to ultimately a decision to prosecute, but also a decision not to prosecute. And obviously other processes are affected by the fact that the CPS is considering a case, potentially the disciplinary proceedings that may take place, but also the inquest. And that ultimately, I'm not suggesting it's unreasonable, but ultimately that is being delayed by the CPS, and therefore there is going to be a real frustration of families if there have been months, frankly more likely years of delay where a case may be being looked at by the CPS, and then especially no prosecution takes place. And then we have the knock-on effect of potentially in disciplinary proceedings in particular, officers saying, well, this is an abuse process. I can't remember, I shouldn't be facing disciplinary proceedings in relation to this issue because of the delay. And we've seen that successfully argued by police officers. So there is a real need for a speeding up of the process, and fully hear you in relation to what you said about the need for experts. But again, that goes back to early engagement with the IOPC as to the relevant experts that they should be instructing. Equally important, who they should not be instructing, because once they've got expert evidence from, frankly, an inappropriate expert, obviously you're stuck with that. And that's a real concern. So I do think that there is that need to engage early on in that process. I mean, one of the things that I think is a real noticeable issue is that those who are engaging from the IPC, the investigators, are not necessarily, it might be their first homicide case, that happens. Obviously, it's always going to be somebody's first case. But in terms of institutional learning and learning of investigators, it's quite noticeable that obviously if you had a police investigating what I might describe as a normal homicide offence, i.e. not involving the police, that they would be specialist homicide officers who are doing that. And I'd be really interested to hear from you as to whether you think that the IOPC should similarly be developing that expertise, where individuals, investigators, are developing that expertise so that they really are only investigating potential homicide offences, so that they can ensure that they have the highest standard of evidence gathering in relation to it, and an understanding of the law around that area, and similarly the experts that they should be instructing. So I'd certainly welcome hearing from you in relation to that, and whether you're noticing any improvements, for example, in the evidence gathering, in the instructions of experts, and in disclosure processes from the IOPC, and whether you think there's any additional improvements that can be identified. There are also issues as to the powers that the IAPC have, and they will obviously have a knock-on effect in relation to the work that the CPS do. And I think we would just be interested in whether you think that there should be additional powers that should be granted to the IAPC in relation to that, if there's anything in particular that could assist the process in ensuring accountability, including potential prosecutions of police officers. One of the issues that you've talked about, Rosemary, but obviously is so hugely important to families, is family engagement. And I noted that you referred to developing a death in custody booklet that was designed for families. I think overall that sounds like a welcome idea, but I think I would say, and I'm sure that Inquest would probably want me to raise, that they are obviously have particular expertise in relation to that, and maybe encourage the CPS to liaise with Inquest in that regard to ensure that the information is the appropriate level and information for the families who receive that. One of the things that I did particularly want to flag is the different experiences that families and people who may be joining this seminar may have had in relation to interaction between the CPS and families. I have to say I've had both positive and negative experiences. The positive experiences have definitely involved families being provided with sufficient information, early information, as much information as is appropriate. And I say that knowing that some family members may be witnesses, and obviously that may make a difference as to the level of information that can be provided. However, as much information, ensuring the confidence of families throughout the process is going to be key in relation to accountability. Obviously, they've had essentially their faith, any faith that they may have begun with in the system, has been shattered by what has happened to them, and the CPS have an important role in ensuring that that is rebuilt if possible, and therefore information being provided, why a particular decision has been made, as to who has been instructed, or particular questions that might be asked. Having that understanding, including engagement throughout the trial, is really important. As I say, I've had both really positive experiences, but unfortunately negative experiences in relation to that. And I think your team, Rosemary, ensuring that it's understood that that engagement is so important is going to be key. Another issue that has come up is victim personal statements. Obviously, these are only going to be needed if there is a conviction. And unfortunately, to date, there have been so few convictions. But one of the issues has been that being asked for at a very late date. And whilst that may be as a result of the IPC not engaging with family members at an early stage, I just flag it because it is incredibly stressful if you are within the criminal process, and this may not just be a homicide offence, that it relates to all prosecutions involving police officers. If families are being asked midway through a trial, please consider doing a victim personal statement. That's extremely stressful experience, and one that should be thought about in advance. I'm conscious of time. I could go on a bit more, but it may be appropriate for Rosemary to respond to some of the things that has been said.
Thank you very much indeed, Helen. Just before I do that, if we ask Rosemary to do that, I just wanted to add a little bit of
Fiona, can I just interrupt to say that the bells of the Commons are ringing and I've got to go and vote. So,
well, that's a shame. Do come back if you can.
Thank you all. I will.
Thank you, David. Yes, there was a concern that there might be a bit of an early vote tonight, so sorry about that, but we did manage to gain the benefit of David's engagement with the issues tonight, for which we're very grateful. Rosemary, I've I've got a number of topics that I've picked out from Helen's presentation that I'm going to ask you specifically to respond on. And one of them is, of course, this massive issue about delay. And we as practitioners in this field are very conscious that the process towards finalising an IOPC report is an extremely lengthy one. And there's a quality assurance process, for example, that can entail an enormous amount of delay. And indeed, what we call ping pong, when the misconduct recommendations go across to the chief officers, the appropriate authority, and there's a disagreement between the IOPC and the police as to what the charges should be. And while that's all happening, the report remains in draft, and the whole process of getting a decision out of your team is delayed. And of course, that's all made more difficult because of Regulation 20 in Schedule 3 of the Police Reform Act, which says you have to have a final report before you make a decision. But there are, of course, two important exceptions. One is circumstances where the IOPC have certified that there should be an accelerated procedure. And secondly, where the DPP, the CPS, have decided that there are exceptional circumstances that make it undesirable to delay criminal proceedings. So when you're addressing the topic of delay, Rosemary, I'm wondering if you could help us as to the sort of circumstances in which you consider the IPC should be certifying for the purposes of acceleration. And secondly, the occasions when the CPS would themselves be willing to indicate that there are exceptional circumstances justifying the matter coming across to you before the report is absolutely finalised. And I noticed in the IPC's statutory guidance that examples are given. And examples for the accelerated procedures are, for example, where the subject or a witness is in poor health or the alleged offence is particularly serious, and there's a concern that that officer remaining in the police service would represent a risk to the public. I'm just wondering, when you're answering Helen on delay, and I think it's such an important topic, I'll maybe ask you to deal with that in isolation from the other topics, which I'll come back to. Could you help us with any examples, further examples that you view as appropriate, either for accelerated procedures or for the DPP to certify that it's an exceptional circumstance? If I could hand over to you on those topics and the topic of delay more generally, Rosemary.
Okay, thank you, Fiona. Is my connection okay on the phone? Yes?
It is. We can hear you. Thanks very much.
It is. Good. Right. I think in relation to, I've made a note of all Helen's points, but starting with the file that we receive, you are correct that it is a final report that has to be produced, and that does take it can take a considerable amount of time, because I think the IOPC are also looking at disciplinary matters and the criminal matters as well. We haven't had a situation in a death and custody cases where we have said there are exceptional circumstances. I think it would be quite a difficult hurdle really to overcome in a death and custody case, because it's extremely important in a death and custody case that we do have a full file of all the evidence and a full report from the IOPC. It would be one of the kind of cases which would be very hard to shortcut in any shape or form. So the only time we have seen exceptional circumstances used was when we used to deal with, and the CPS still do, of course, deal with lower level cases where there might be a statutory time limit, or cases where there is some real risk, which is the other type of case you have referred to, and a need, obviously, for that officer being a risk to the force or a risk to the public, etc. But in relation to the standard death and custody case that we would be looking at, it would be extremely important that we have a full report and we have a full file of material. And that actually is the crucial point for us, because quite often, in a considerable amount of cases, we receive a file which should be a full file, but in fact we see lots of things that still need to be done. And that can delay the process, which is what comes back really to Helen's earlier point about the early engagement and picking up on all the things that perhaps could be done a lot sooner. if we're engaged in the process at an early stage and in some kind of, a very active role. I think that is probably the key. I know that there are changes that could be made to the Police Reform Act, which might improve matters, but that's quite a weighty subject and probably a subject in which the IOPC would be best placed to comment. But that would be my response very quickly to that, because I know you're running out of time.
Yes, absolutely. Well, I think it might be interesting to take into another forum a debate about the value and the lack of it for waiting around for misconduct decisions to be made before the CPS engage on crime. But that's probably a discussion for another day. I've got grouped as topics from Helen the potential value of a cadre of specialist investigators for homicide cases from within the IOPC, whether they need further powers, whether you will consult inquest on the booklet. And I've also got a couple of questions from the audience, which I'm hoping to squeeze in, but perhaps if you could rattle through those topics, Rosemary, we'd be grateful.
Absolutely. I agree with every point that Helen made. I think particularly in relation to specialist officers, that to me is crucial. I think the experience necessary to investigate these cases and to produce a file for the kind of quality of file that we need for a death in custody case is absolutely key. So to have somebody who's properly trained in homicide offences and the difficulties and the legal elements of the offences that we deal with, the standards that we need, who has a considerable training in relation to disclosure, which is absolutely crucial. I couldn't agree more that it needs to be dealt with by specialist officers, very experienced officers in the IOPC. With family engagement in relation to the death in custody booklet, we would absolutely welcome that. So as soon as we have a draft that we think is in more or less a good final form, when I say draft final form, we would absolutely welcome the experience and the expertise of inquest and having a look at that booklet. So that's an offer we shall certainly take up. And for family feedback as well, that would be another thing we'd be very interested in. So we do in every case a post-case review, looking at, particularly in a case that's been prosecuted, but in every case, but to look at what went well, what didn't go well, what we could do better, what are all the areas of improvement. And a very crucial element of that is feedback from the family, which we would really welcome. So if there's any way we could liaise with Helen and the people that Helen works with in order to get feedback from the family, both on the cases that have gone well and the cases that families feel have not gone so well for family liaison, that is absolutely key for us. We would welcome that. Victim personal statements, I know Helen's also mentioned that, and then being asked for at a late date. That's very, very interesting feedback, very good feedback. That's obviously something we can absolutely take on board straight away. I know that in some cases, not in particular death in custody cases, but in other cases that we've had, some families prefer to leave it to the end of the trial. And they put into their personal statement the impact of the trial as well. I've seen that happen. But if the feedback is that families would much prefer that to be something they engage with at the beginning of the process or the beginning of the trial, then absolutely we will take that on board. I think that was most, training as well. Training, of course, is hugely important. And if we can help with training, we certainly will.
And that includes training of the IOPC. Rosemary, I think you've previously mentioned. A number of very interesting questions from our audience. I'm going to take them in reverse chronological order in terms of how they've come in. Two of the questions actually concern the institutional issues that the Metropolitan Police have been identified as suffering, institutional racism, and following the Daniel Morgan report, institutional corruption. And a member of the audience who hasn't given their name asks, how does the CPS approach allegations that use of force was racially motivated, or at least informed by racial stereotyping or racist tropes? Is institutional racism ever considered? Do you have regard to the McPherson report? Do you have regard to Angelini when you're making decisions? All of this, of course, the questioner appreciates sits within a wider context that racist hate crimes and hate crimes more generally are poorly prosecuted. So I think it's the interface between the broader issues of race and prosecutorial decisions in relation to the police We'd be grateful for your comments on that aspect.
Well, of course, I could only comment on the cases that we deal with, but race is certainly in any case that we look at. If there is any racial element that we can see, we will. That will form part of our case. So, for example, in the Daly and Atkinson case, I suppose it was clear that there was no evidence of any racial element, and therefore that wasn't part of the prosecution case. If there was clearly a racial element, then that would be part of the prosecution case. So that would be looked at in any case. In relation to wider CPS, of course, there is hate crime flagging, and that's another topic, I suppose, entirely, because that would permeate all offences. In relation to the police, if it is raised as an issue and if there is evidence of it, then that will be something that would form part of our decision making and part of our prosecution.
And Rosemary, I think you'd agree that the point you're making there comes back to the point that both you and Helen have emphasised, which another questioner, Patrick O'Connor QC from Chambers, raises, which is that it has to be got off, the whole investigation has to be got off on a correct footing from the very off. And in the example we're discussing around how race is addressed, it's going to have to be important, as we've heard in the media, to examine the officer's social media accounts and endeavour to seize evidence that could assist a prosecution in identifying a racist motive or motivation on the part of the suspect officers. Would you agree?
I would agree. I mean, I think what obviously, if it's part of the evidential case that we're looking at, I think it has been a very interesting development, and we've seen it in many cases, not just death and custody cases, of course, in cases across the board, where social media accounts have provided very concerning information about officers' behaviour in certain cases, and that is a matter I know that's very much in the media at the moment. But it is something that's very important to consider.
Relatedly, Patrick O'Connor, who is a veteran in these cases, in fact, back when I was a solicitor, I instructed Paddy in challenging decisions reached by Barbara Mills in respect to the death of an Irish traveller called Richard O'Brien, which led ultimately to a prosecution taking place many years after the event. And Paddy wonders whether it's still possible for a post-mortem after death in custody to take place even before reasonable steps have been taken to inform the family of the deceased, and Paddy references experiences of those post-mortems occurring with the Police Federation instructed pathologists present, but not the family's pathologists present. From your experience, Rosemary, is that still happening? And if so, what steps are being taken to make sure it doesn't happen?
I'm not sure I exactly understand the question, I'm going to be honest.
Sorry, let me make it a little bit clearer. So, Rosemary, families have a right to be informed that a post-mortem is going to take place. And the purpose of that right is to facilitate their instruction of a pathologist to attend on their behalf as a representative of the family. We've all had a lot of experience of being notified that the post-mortem has already taken place, so that the family don't have an opportunity to have a pathologist present. And even worse, to find out that the Police Federation have instructed a pathologist who has attended. And that then means that the coroner's post-mortem and the Police Federation's pathologist have a greater access to the independent evidence, the objective evidence of the post-mortem than the family's pathologist, which creates an imbalance and unfairness. And the question is really, is this still happening? I know it didn't happen in Daly and Atkinson. I know that the family were there right at the outset.
I'm afraid I actually don't know. I wouldn't know the answer to that question. That might be a question that perhaps coroners may be better able to answer.
I understand. Let me see if we can pick that up elsewhere. A question we had hoped David would be around to answer, but I wonder if you have a view, Rosemary, Helen, or indeed Maya. Let me throw it out to all three of you. And it's back to the fact that the Met is both institutionally racist and corrupt. I have been found to be. And the questioner poses is Sion Morgan from Hodge Jones Allen Solicitors. Is the only viable solution to dissolve, abolish these institutions and start from scratch?
Is that a question directed to me, Fiona?
Perhaps all three of you would give your views on that. Go ahead, Rosemary.
I think from my point of view that's not a question I would really be in any position to answer. So I'd have to rely on my fellow panel members.
All right, but fair enough, Rosemary. Maya, what do you reckon? Should we just dissolve the Met and the IOPC and start again?
I hate this question because, you know, the more radical thinkers, those of us, really have to go on mute because I can hear you typing. Fiona. Yeah, it's one of these difficult questions where, you know, sort of more radical thinkers than me don't believe that there's any hope with the tinkering and we should just all be abolitionists. And certainly that was the thinking of a lot of Americans post George Floyd. But on the basis that we have to have some sort of structures for, you know, that policing isn't by definition a bad thing. I just don't see where we would get to from abolishing this. Let's take the Met, for example, abolishing it and starting the recruitment process all over again, because I do think that there's an issue with who wants to be a police officer and where you draw that cohort of people from, and whether it's you're just going to recreate the same issues, because it's a societal issue as well as a structural issue. So you break down the structure, build another structure, but we're still back to an institution that's going to replicate these societal problems. I totally understand this kind of, you can train people and you can train people and you can train people, and there's still this massive gap between training and policy and practice. But yeah, I'm afraid slightly lame answer. I can't see that just sort of dismantling what we have and starting again. And also, what happens? I always ask myself this: what happens in that interim period when you dismantle everything? What goes on? Do we have complete chaos? You know, whilst we're rebuilding. What do you think, Helen?
Anything further from you on that, Helen? Do you tend to agree with Maya's position?
I do. I mean, I slightly struggle. I mean, you know, I just think of, you know, in relation to the IOPC, we had the Police Complaints Authority, then we had the IPCC, now we've got the IOPC, you know, focusing on the expertise that, you know, what getting right and progressing that. For example, as we've been discussing about the idea of specialists, investigative homicide investigators in the IOPC, developing that expertise seems to me to be so crucial. And what are we going to do? Completely lose that if we dismantle the whole structure to begin again? That's where I do have concerns. I mean, if somebody wants to present this is how it would work, I'd be thrilled to see that, but I slightly struggle with it, I'm afraid.
Yeah, well, for what it's worth, I tend to agree with both of you. I mean, it seems to me one of the most interesting ideas that we've been discussing tonight is about the idea of a cadre of specialist investigators for the homicide cases. And I very much hope Rosemary and indeed Helen, who continues to hold a brief for inquest and liaison with the CPS, follows that up, because I think I've certainly seen some very good investigations by the IOPC, and I've seen some good work by the CPS. What we really need to be working on is consistency and ensuring that some of the ingrained patterns that are operating as obstacles get ironed out of the system, which again, I think tonight we've had a lot of reason to talk about delay. And I think I'd certainly like to follow up on the approach of waiting to the final version of the report and what we can do, whether through legislative reform or from using the exceptions to try and get the CPS engaged with the decision long before the final report is eventually signed off. And there's a lot of other interesting matters to follow up. Thank you very much indeed, Rosemary, for offering to address the feedback that Helen's offering and for consulting with Inquest with regard to the booklet. I'm sure there's a lot of positives that we can build on from this discussion. We've run over time a little bit because we started a little bit late. I'm sorry not to have had David available for the Q&A, but that was always going to be a risk for him tonight, given events in Parliament. And I think it just remains for me to thank everybody for attending. Thanks everyone for all the interesting questions, and indeed to Helen, Rosemary and David for the care and thought they've put into their submissions tonight. Thank you very much indeed. And watch this space for the next in the series. We're not going to announce the plan just yet because we're still endeavouring to formulate it. But I think we've got a date penciled in the diary for February, haven't we, Maya?
Yes, we do. I think at the moment, mid-February, but yeah, watch this space. It's going to be good. We just
we think it's going to be very exciting, but we'll need to get a few things bottomed out before we announce it. Yeah. Thank you very much, everyone. Hopefully see you all in person sometime soon.